Recording is now begun.
Welcome to today's program, Protecting Trade Secrets and Enforcing Restrictive Covenants Internationally. Copies of the slides, a link to the recording, and the CLE verification form will be emailed to you in the days following the webinar. During the program, a CLE code will be read aloud, and you will be required to include this code on the CLE form. Throughout the webinar, please feel free to type your questions into the Q&A box on your screen. Now, I'd like to turn it over to Dan Hart.
Thank you, Colleen. Good afternoon and happy St. Patrick's Day. My name's Dan Hart. I'm a partner in Seyfarth's Labor and Employment Group based in Atlanta, and it's my privilege to welcome you to the second installment in our 2022 Trade Secrets webinar series. Over the next hour or so, we're going to provide you with an overview of strategies for protecting your trade secrets and enforcing restrictive covenants internationally. And I'm pleased to be joined today by Caitlin Lane, a partner in Seyfarth's International Group based in New York, and also Jesse Coleman, a partner in the litigation group based in Houston. We can move on to the next slide, that'd be great. The slide on the screen lists our aims for today. To get started, I'll provide a brief overview of the most common ways to protect trade secrets. Caitlin will then address enforcement mechanisms outside the U.S., with a focus on a handful of countries as examples. Jesse will then discuss enforcement and remedies that are available under U.S. law. And then finally, I'll provide what I hope are some practical tips. We'll also reserve some time at the end for questions, but don't feel that you have to hold your questions till the end. Feel free to send them at any time using the webinar's chat feature, and we will get to them at the appropriate time. Next slide. Now, to start our discussion, I'd like to set the stage with an overview of the usual mechanisms for protecting trade secrets. And as an illustration of the risks that companies face, I'm reminded of a story that I read in the Wall Street Journal about 10 years ago. We don't have the citation on the slide, but the story was entitled, "Engineer Gets 4 Years in Motorola Secrets Case." And that was from the August 29, 2012 issue of the Wall Street Journal. And the article told a story about a former software engineer at Motorola who was sentenced to 4 years in prison for stealing trade secrets from the company and then trying to abscond with those trade secrets across international borders. According to the article, authorities stopped the engineer during a routine screening at O'Hare International Airport, and it's then that they discovered she had $30,000 in her luggage, more than 1,000 confidential documents, and a one-way ticket to Beijing. Now, that's an extreme example, but it illustrates the kinds of threats that companies face. And with no disrespect to the good people at the Department of Homeland Security, I think that most companies want to rely on something more than security checks at the airport when it comes to protecting their trade secrets. Next slide, please. So how do companies protect their trade secrets? Well, many countries have statutes that companies can rely on. For example, later in the webinar, Jesse will talk about some of the remedies available in the U.S. under the Defend Trade Secrets Act. Some common law countries protect trade secrets using common law tort claims, such as a claim for breach of confidence. But aside from statutory and common law remedies, restrictive covenant agreements are usually the most common mechanism we see for protecting trade secrets. Next slide, please. And in the US and in some other countries, restrictive covenant agreements usually include several different covenants that all work in tandem. Usually, an agreement will include a covenant prohibiting the use or disclosure of trade secrets or other confidential information. In jurisdictions where they're allowed, the agreements may have customer non-solicit covenants. They may have covenants that prohibit the solicitation or recruitment of employees. In places where they're allowed, they may also have a non-compete covenant. And by a non-compete covenant, I'm referring here specifically to a covenant that prohibits an employee from being employed by a competitor for a certain period of time, or precludes somebody from operating a competing business for a certain period of time. Next slide, please. So where do we typically see restrictive covenants? Well, most companies in the U.S. have probably encountered these kind of covenants in transactional agreements at one time or another. They're almost always in M&A deals and other sale of business agreements. Sometimes you see them in agreements used with vendors like a master services agreement. And aside from transactional agreements, they're often used in employment agreements, which is the focus of a lot of the content today. Now, here I'll note an important distinction about U.S. law that's different from the law in pretty much the rest of the world. In the U.S., at least in most states, employment is at will unless an employment agreement provides otherwise. And so the vast majority of employees in the U.S. don't have individually negotiated employment agreements. For these employees, which again is the vast majority of them, restrictive covenants are usually included in a standalone agreement, like a standalone non-competition agreement, proprietary information protection agreement, etc. It's also common to have them in incentive compensation agreements, things like stock option awards or other deferred comp agreements. And for the small group of U.S. employees who have individually negotiated employment contracts, restricted covenants usually would be included, at least in states where particular covenants are allowed. Some employers will also include restricted covenant agreements or restricted covenants in severance agreements, and I'll talk about that in a little bit later during the presentation. And so these are all pretty common to employers in the U.S. Now, it's less common in the U.S. for employers to use garden leave or other notice provisions, but those kind of provisions are much more common in other countries. And with that, I'll hand it over to Caitlin.
Thanks, Dan. Next slide, please. As Dan mentioned, notice periods are another source that can be used to protect trade secrets and confidential information. And this is, as he mentioned, more common outside of the U.S. In many countries outside of the U.S., employees are required by law to provide advance notice to their employer when they are going to resign. And in many countries, the parties can actually contractually agree to an even longer notice period, so longer than what is required as a minimum under law. What this means is that in some places, employers can actually leverage notice periods to prevent employees from immediately moving to a competitor because the employee needs to serve out their required notice period. Most often in practice, we want to stop employees from having ongoing access to confidential information and clients, and an employee can be placed on garden leave, which is essentially they remain on payroll, they're still employed, but they're on essentially a paid leave of absence. They're not working, they're no longer having access to that confidential information. There are some limitations to this approach. Most significantly probably is the fact that in some jurisdictions, an employer can't require an employee to provide more than the statutory notice period, and where that is quite short, this approach may not be the most helpful. In some cases, there's also a right to work that employees may have in their given country. But as a general matter, this is something to consider when we look at what are the overall options for protecting trade secrets and our confidential information. We'll explore this concept a bit more with some specific country examples. Next slide, please. So the first topic we want to really dive into as far as enforcement is concerned is on the international stage. Next slide, please. So when we think about international enforcement and multinational employers, we have to kind of frame our thinking to some common considerations. And when we look at how to best protect trade secrets and confidential information in any given country, there are a number of things that we need to think about to get a well-rounded approach. As Dan mentioned, one of the most common approaches is to limit competition after employment. And a key question that always comes up is about enforceability. Are my restrictions actually going to be enforceable? And the ability to enforce will vary by jurisdiction. You will run into limitations on what activity you can prohibit. How long can you prohibit certain competitive activities? How far can the geographic scope of the restriction extend? There's also going to be local requirements that need to be taken into consideration. So, for instance, certain local language requirements, meaning an agreement has to be in dual language, it can't just be in English, or the requirement to pay compensation to an employee during the restriction period after they have terminated their employment. If these local requirements are not in place, you may have an enforceability issue right off the bat. So these are things that we really want to take into consideration when coming up with a global strategy. There's also questions about what relief can be obtained. In some jurisdictions, there's not a quick, immediate relief like an injunction. So you could end up in court for a significant period of time before you're actually getting the desired outcome. In some cases, the relief is really limited to damages. And on that point of damages, it's often not enough to simply say that somebody's working for a competitor and so they're therefore violating. Oftentimes, a company will need to demonstrate actual damages from the competition with specificity. To that point, there's time and cost considerations. In some places, having a non-compete is a great deterrent, but in practice, it may not be practical to enforce in certain cases. So all these considerations go to the question of what's the best way to protect your company's trade secrets globally? You may not be able to enforce a non-compete in certain situations, but perhaps you can enforce a longer notice period, or perhaps you can rely on a statutory trade secret protection. So thinking through these points and understanding the local requirements and regulations really is critical to developing a tailored strategy for each jurisdiction. Let's take a look at some specific country examples. Next slide, please. So the first on our list is China. And in China, it is possible to have an enforceable non-compete agreement, but non-competes will generally be limited to certain positions. So those are your senior managers, senior technical people, employees that have access to trade secrets. And the scope of the restriction will need to be limited. It needs to apply to other businesses that produce the same products or engage in the same type of business. Similarly, time periods will need to be limited, with 2 years being the outer max. That doesn't mean that you would give 2 years to every employee. You're really looking at this on an individualized case-by-case basis to determine what's appropriate to protect our trade secrets and our confidential information with this particular employee. And China is a jurisdiction where compensation has to be paid for the duration of the restricted period. That means that even though the employee has left their employment, when they are being restricted from competing, they need to be compensated. The amount is typically negotiated at the time that the non-compete is entered into, and if the compensation is not paid during that restrictive period, there will be no ability to enforce. So there's compensation considerations on both ends. On the front end, when you're preparing these agreements, it's thinking about what do we want to agree to and what will an employee agree to as far as a compensation figure. And then on the back end, making sure that that compensation actually gets paid. As far as remedies are concerned, injunctive relief is difficult to obtain in China, and instead liquidated damages are much more typical. So when you're thinking about how am I enforcing, thinking about what the potential remedy is may influence the decision of how far do we push this. Is this something that we want to go to court over? China also has trade secret protection under statute, but these protections can only go so far. So examining the workforce and tailoring non-competes for appropriate employees will really be the best protection. Employees in China are required to provide notice when they resign. So in most jurisdictions, that'll be 30 days. If they agree to a contractually longer period, only that statutory period can be enforceable, but it's another mechanism in the arsenal. And the beauty of it is it's not you don't have to choose only one. I think the point is to demonstrate that you want to be thinking about the requirements for non-competes, the notice guideposts, and thinking about how do we best tailor our protections. Next slide, please. In Colombia, in contrast, non-competes are generally prohibited, and that's irrespective of the seniority of the employee. It is, notwithstanding, common practice to include non-compete provisions in the employment contracts of employees. And this is really for deterrent effect and creating a moral obligation on the part of employees. Very common to have them, but as far as enforcement is concerned, there really is no mechanism because as a matter of public policy, the non-compete agreements are unenforceable. For this reason, your confidentiality and non-disclosure agreements will be really important for protecting trade secrets. And so it's thinking about what are the appropriate documents that we're getting in place, what's going to actually help us if we run into a problem. As far as the notice is concerned, in Colombia, employees are legally required to provide notice if they resign, but in practice, this often doesn't happen because there's no enforcement mechanism, and often employees will resign with little or no notice at all, and there's really no recourse. One approach is to try and enter into a contractual notice period, although this is not particularly common, but it may be an approach that you can consider with more senior employees. Ultimately, the ability to enforce that notice period will be based on a matter of good faith by the employee at the time of their resignation. Next slide, please. So hopping over the globe to France, in France, non-competes can be enforceable, but they must be reasonable, and the employer must pay compensation for the duration of the restriction period. And in France, what is reasonable is viewed quite narrowly. There must be a legitimate business interest, and the restriction has to be closely tied to that specific employee's role. It also can't prevent the employee from engaging in their profession. So even if the restriction is narrowly tailored, if the person has a specialized skill and the restriction prevents them from carrying out their skill, that would be something that would ultimately likely not be considered reasonable. As far as time periods are concerned, the restriction can't be longer than 2 years, and again, that's a max. It needs to be tailored appropriately, and often a shorter period may be more appropriate. Likewise, geographic scope also has to be specifically tailored, and it has to be specific and supported by the business interest. Most courts will limit this to France as opposed to going out into the greater EMEA areas that may be kind of surrounding countries. And importantly, in France, minimum compensation does have to be paid. The amount that has to be paid is typically set by the applicable collective bargaining agreement, and this can be upwards of over 50% of salary, sometimes upwards 60, 70, 80%. So it's not a small amount. It's something to think about when deciding which employees should get these restrictions. Are we going to want to pay for this? Because that's the only way it will be enforceable among meeting the other reasonableness requirements. In France, interim relief is available. Typically, agreements will include a penalty clause that requires the compensation to be returned in the event of breach. And while this is certainly a deterrent, employees don't want to lose the compensation benefit. If a company is not particularly concerned about the monetary value and is really focused on preventing the employee from the actual competing activity, the process to get there can take a significant amount of time. France does also have trade secret protection under statute. This is another avenue for protection, but as discussed previously, it's generally advisable to utilize multiple strategies and not simply rely on the statutory protection. Certainly, if there was a breach situation, you would want to be able to ensure the protection of the confidential information and trade secrets through multiple approaches. So statutory protection as well as non-competes, if appropriate, being two of those. From the notice perspective, employees in France are required to provide notice in the event that they resign. And typically, employees in France will work during their notice period. But if they're placed on garden leave, they can't be prevented from working for another employer. And this stems from the fundamental right to work that all employees in France have. And so when we think about the notice period approach in France, it's really thinking about, do we have an ability to utilize that notice period in a way that keeps them on, but reduces risk that confidential information could be either taken or utilized in the wrong way. Next slide, please. So jumping over to the APAC region in Hong Kong, non-competes can be enforceable. They must be reasonable in scope, time, and geographic location, and they must also protect a demonstrable proprietary interest, such as trade secrets or proprietary business information. And that's a really important prong when it comes to analyzing whether the restriction will be enforceable. Non-competes in Hong Kong are also very strictly scrutinized in terms of time limits. It's very difficult to enforce non-competes that exceed 6 months, and courts will not blue pencil. So it's really critical to ensure that Hong Kong restrictions are drafted with proper time restrictions to ensure that you're not jeopardizing enforceability based on something that really is a fairly easy thing to ensure is correct in the first instance. As far as remedies are concerned, Hong Kong does have an avenue for seeking injunctive relief. This may be seen as more favorable than monetary recovery for some employers. It's a bit more similar to injunctive relief that we might be able to get here in the US. But unlike China and France, Hong Kong does not have statutory protection for trade secrets. Trade secrets are protected by common law, and there's case law that can be of assistance, but it's not something that is protected by statute. As far as the notice approach is concerned, Hong Kong is a bit unique, and because of this, the notice approach is not one that may necessarily work there. While employees are required to provide their employer with notice if they're resigning, they actually have a statutory right that can't be waived to buy out their notice period. So oftentimes if an employee is leaving to go to a new employer and that new employer wants an employee to start right away, the new employer can essentially fund the notice buyout. This could happen, for instance, through an enhanced sign-on bonus. Next slide, please. And in our last stop around the globe, India, another comparator. So in India, post-employment non-competes are void. They are unenforceable. Employment contracts will typically include non-compete provisions that are enforced for the duration of the employment relationship, but as soon as that relationship ends, that protection expires. And because trade secret protection is grounded in common law and contracts, there's really typically an emphasis on very strong non-disclosure and confidentiality agreements from the contractual perspective. The kind of sanctity of contract is something that we see in India being used to protect trade secrets. And as far as the notice approach, that's something that typically can be a workable avenue in India. Employees can actually agree to notice periods that are longer than what is statutorily required, and as long as both parties have the same obligations, those agreements will generally be enforceable. What we need to avoid is requiring an employee to provide some long notice period, but the employer does not have that same reciprocal obligation. So ensuring fairness to the employees will help with enforceability there. Next slide, please. So we've gone through a few examples. What does this all mean? I think one of the biggest takeaways is that one size does not fit all when it comes to protecting trade secrets across multiple jurisdictions. Companies have to be mindful of local legal requirements for valid restrictive covenants and taking into consideration the place where the employee works and where employees are likely later to compete. And it's thinking about whether non-competes are the best option every time. I think as we've seen, there are some places where it may make sense. It may make sense for a handful of employees, but there are also places where payment is required, where injunctive relief may not be available. And so non-competes may not be the most expedient means for protecting the company. It's also important to bear in mind that even where parties agree on a governing law or forum, the courts in local jurisdictions often apply local law requirements and will void any restrictive covenants that do not comply. So for instance, if a U.S. company decides that they're going to use the U.S. restrictive covenant agreement everywhere, and there's employees overseas that have that, it may be that we can't actually enforce on that basis because a local court will take the local view. I think it's also important to remember that trade secret default statutory protections only go so far. And while there are countries that make trade secret misappropriation unlawful, this protection may not be helpful unless the company is taking active measures to define and protect its proprietary information. And how do you do that? Companies should execute confidentiality agreements that adequately define what the company considers confidential and proprietary. Putting in place technological and security protocols to restrict access of the company's most valuable proprietary information is also important. Failure to take these protective measures at the outset can, in some cases, undermine a company's claim that certain information actually constitutes a trade secret. It will also be important to be mindful that security precautions don't interfere with privacy rights. That's particularly important in Europe. So what this all ultimately boils down to is that companies should formulate a thoughtful strategy for global trade secret protection that takes into consideration local nuances and local requirements. With that, I will pass it over to Jesse to discuss the U.S. enforcement and remedies.
Thank you very much, Caitlin. First thing I want to start out by saying is one of the real pleasures of working at an international law firm like Seyfarth Shaw is that I get to take advantage of the incredible depth and breadth of knowledge that my colleagues have. That I learn new things constantly. Just listening to Caitlin's presentation and Dan's presentation so far, despite my practice and the time I've worked internationally and nationally in trade secret work, I'm still learning new things. And so just want to put a shout out to them. They're incredible colleagues on this. So thanks for that. We already have a question on the board here, and let's see if I can answer this. What role can arbitration play in a trade secret restrictive covenant enforcement strategy? It's an excellent question, and it plays a very large role. Oftentimes, arbitration is the best way to go about obtaining relief. It avoids local courts. It avoids the long processes that might be engaged with private civil enforcement actions. It might avoid all sorts of costs and questions about choice of law, choice of forum, arbitration processes, particularly if they're binding arbitration processes, either between sophisticated parties or between consensual parties to an agreement, can often streamline a process. There are some downsides to it. Arbitration processes can be more expensive. They can be more, they can take more time in some respects. The costs can relate to having to pay the arbitrators. Oftentimes, however, the agreements address a lot of these issues and involve cost sharing and risk sharing. And there are some risks with regards to how an arbitration panel might address something that's different from a court. So there isn't a one-size-fits-all answer to that question, but I do believe that arbitration plays a very large role in a trade secret enforcement strategy and is often the correct route on that. So happy to answer any follow-up questions on that issue as they come up. Moving into my area that I was going to speak about here today, it's going to be U.S. enforcement and remedies. So you are an international company, you're a globally placed company, but you find that the local circumstances on the ground are not favorable to trade secret enforcement and protection of your protectable business interests. Are you out of luck? Are there reasons to stop the process at that point? No, not necessarily, particularly if you have a U.S. presence and some of the other elements that I'm going to address here are met. U.S. enforcement, private civil U.S. enforcement is often the most direct route, even if the harm is felt globally, internationally, or largely in another area. And so we're going to talk here in this next section about U.S. enforcement and remedies. And one of the things I'm not going to talk about before I go to the next slide, I'm not going to focus on criminal protections. That's something that's handled largely by the government. What we're going to be focusing here on are largely civil enforcement and remedies. So with that, if we could go to the next slide. So the first thing I'm going to talk about is kind of the overall international framework of our laws and where we have, the United States has obligations towards the international community. And by international community, in this particular case, I'm talking about the WHO, and so, or excuse me, the WTO, the World Trade Organization, and that is the Agreement on Trade-Related Aspects of Intellectual Property Rights, or TRIPS. And this is not to discuss specifically any sort of private civil enforcement action under TRIPS, but rather the framework in which the United States has agreed to set forth its own domestic laws. And then we're going to look at those domestic laws. The two primary ways of civil enforcement to protect trade secrets in the United States and extraterritorially for harm in the United States or relating to U.S. citizens and related parties is the International Trade Commission Section 337 and the Defend Trade Secrets Act, or the DTSA, which you'll be hearing a lot about today. So next slide, please. Speaking briefly on TRIPS, this is a multilateral agreement on intellectual property between all members of the WTO. The United States entered or joined the TRIPS in 2005, and it protects all forms of intellectual property, or most forms, I should say, of intellectual property. I'm sure there's an argument to be made some IP is not covered here. But for purposes of our discussion here today, it specifically includes trade secrets. This treaty sets out the minimum standards of protection to be provided by each member being the member state, sets out domestic procedures and remedies for the enforcement of those intellectual property rights, and creates or makes disputes between the members about the respect of those obligations subject to the WTO's dispute settlement procedures. And generally, when in regards to the private enforcement mechanisms, they follow generally along the lines of what you would expect. There must be civil judicial procedures available in respect to any activity infringing intellectual property rights. There must be due process. There need to be rules on evidence in the statutes that are passed by the member countries. There needs to be power by the courts to order injunctions, to order cease and desist, to include the possibility to prevent importing infringing goods from entering into the domestic distribution channels. The TRIPS requires that domestic courts allow for damages, to require the infringing party to pay the right holder adequate damages, including attorney's fees. And they must have the authority, the local courts, to order infringing goods to be disposed outside of the channels of commerce or, where constitutionally possible, destroyed. So those are some of the obligations that the United States has agreed to on the world stage with regards to its laws. So let's go ahead and take a quick look at some of those laws. Next slide, please. The first one we're going to look at is ITC Section 337, which is really 19 United States Code 1337, or Section 337 of the Tariff Act of 1930. What this allows for is the International Trade Commission, which is a federal agency, to adjudicate cases involving companies that exploit U.S. IP domestically and abroad, and this includes trade secrets. And the seminal case in this is a 2011 Federal Circuit case, Tianrui Group versus International Trade Commission. Tianrui involved the exclusion of steel railway wheels that were manufactured abroad using misappropriated trade secrets. The acts of misappropriation in this case undisputedly occurred abroad. Tianrui, a Chinese company, had also hired 9 employees from a licensee of the plaintiff, and they had knowledge of these proprietary processes that were disclosed to Tianrui. They used that to make a competing product and import it into the United States. Although all alleged acts of misappropriation occurred in China, the ITC issued an exclusion order against Tianrui. It determined that under 337, unfair methods of competition and unfair acts in the importation of articles in the United States allowed the Commission to look to conduct occurring in China in the course of trade secret misappropriation investigations, insofar as it was necessary to protect domestic industries from injuries arising out of unfair competition. The court further determined that the fact that the case involved imported competing products that incorporated those trade secrets constituted injury to the industry within the meaning of 337 that prohibited acts of unfair competition that threatened to, quote, destroy or substantially injure industry in the United States. And that this was true although no domestic manufacturer was even currently practicing the protected processes, and instead the producer was using another protected process. So as you can see, the scope and the impact of Section 337 is broad and it extends beyond the United States under those terms that we just discussed. Now, there's some pros and cons associated with ITC 337. Next slide, please. Number one, it moves relatively fast. Anyone that's been involved in trade secret litigation knows that 9 to 18 months is a very fast case. Sometimes you can get that in civil district court. Oftentimes these types of cases can last much longer depending on the judge and the docket that you're in the jurisdiction. Speaking of jurisdiction, one of the pros is that you don't have to have personal jurisdiction over the offending company. In rem jurisdiction over the offending materials is sufficient. Oftentimes, going under ITC Section 337 can avoid choice of law issues that might arise otherwise. There's less variation in IP familiarity in that the ITC is more likely to issue uniform laws and uniform decisions based on its own case law, and you're not bouncing around between circuits and other judges that may be looking at different strains of case law that are addressing various statutes. The ITC can issue cease and desist and general exclusion orders, and there can be fines that are associated with failing to adhere to those. And finding of trade secret misappropriation in such an investigation may be used. There's been at least one district court that has found this, can be used in a later trade secret misappropriation case in a district court. The problem is that these proceedings can be very expensive. They are often on a dual track with a civil district case. The ITC is not going to give you money damages. Their job is much more injunctive and equitable. And if you lose at the ITC, just like that, the win could be used in a later district court action. It's potentially preclusive in its effect on later claims. Next slide, please. I'm going to spend the remainder of my time speaking about the Defend Trade Secrets Act, and with the understanding that you're generally familiar with the Defend Trade Secrets Act as it applies in the United States. DTSA is just as a quick primer, it's a federal cause of action, as Dan had talked about. It is a national cause of action that when in interstate commerce, trade secrets are misappropriated, you can bring a federal claim. And it allows for damages, it allows for punitives under certain circumstances, punitive exemplary damage recovery, and attorney's fees along with injunctive relief. What I'm going to be focusing on for the balance of my time here is the extraterritorial impact or effect of the DTSA. And there is a specific provision in the DTSA that identifies that it can apply to conduct occurring outside the United States. First, if the offender is a natural person or citizen or permanent resident of the United States or an organization organized under the law of the United States or a state or political subdivision, or, and this is the big one, an act in furtherance of the offense was committed in the United States. And so we're going to be focusing a lot on this act in furtherance language in the cases that we're going to be looking at here. Courts have applied DTSA extraterritorially pursuant to the terms of the statute. And let's go ahead and look at a couple of the cases here. Again, we have a seminal case that a lot of folks look to. Next slide, please. And I got to walk back and talk to Dan to find out if that Wall Street Journal article involved this Motorola case, because we've got the civil action going on here, and you've got some guy that's absconding with or some lady absconding with the trade secrets and $30,000 in cash. I wish I'd have known about that. We could have tied those together. My bad on that, but we've got this case here, Motorola Solutions versus Hytera back in 2020. I'd say this is probably later in time, but as I said, you never know how long these matters drag on. So in this case, Hytera allegedly, well, Motorola alleged that the case has gone and there has been a jury verdict in favor of Motorola. Motorola alleged that Hytera, a Chinese company, hired 3 engineers from Motorola's Malaysian office, and those engineers stole confidential documents containing Motorola's trade secrets. Motorola alleged that they used those trade secrets to develop a digital radio similar to Motorola's product and sell it around the world. Hytera moved to preclude seeking extraterritorial damages. They argued that damages awarded under DTSA should be limited to domestic actions. District Court denied that motion and held that the defendant had advertised, promoted, and marketed products embodying the allegedly stolen trade secrets domestically at numerous trade shows, which constituted use of the alleged trade secret under the DTSA. And went on to find further, the Northern District of Illinois, that even if the DTSA did not have territorial reach, the case would still present a proper domestic application of the statute because Hytera's use of Motorola trade secrets and products Hytera advertised and sold in the U.S. met the definition of misappropriation. Next slide, please. So another case on this point here, back in my backyard of the Eastern District of Texas, we had a case where the alleged trade secrets were misappropriated in Israel. All products allegedly incorporated them were made in Israel. But again, the sale of the products in the U.S., in this case, constituted use of the trade secrets, or in the alternative, the U.S. sale of those products constituted an act in furtherance of trade secret misappropriation. But I need to point out that in this case, this is the Illuminati Networks case, the court put a kind of far end protection on what constitutes an act in furtherance, and it applied the U.S. Supreme Court case of Yates to the United States, which is not a trade secret case, in discussing in furtherance, and said that an act in furtherance need not be the offense itself or any element of the offense, but it must, quote, manifest that the offense is at work and not simply a project in the mind of the offenders or a fully completed operation. So put another way, an act that occurs before the operation is underway or after it's fully completed is not an act in furtherance of the offense. Well, it found that here these acts were in furtherance, but we have one more case I'm going to look at here on this particular point. Next slide, please. Let's go up one more slide and we'll come back to this one if that's okay. There is another case, Pro V International versus Rubens, that dismissed the DTSA claim on the motion to dismiss because the court found that the only alleged U.S. connection to trade secret misappropriation was the employee's travel to a trade show and tendering his resignation in the U.S. before beginning his job at the defendant's Brazil location. And these acts did not constitute an act in furtherance of the offense, even though the alleged trade secret misappropriation had occurred, but it had occurred in Brazil. So this is kind of the limits on, or one application of the limits to DTSA extraterritoriality. So if we go back one, I'm not going to read through all of these. If we go back one slide, these are potential acts in furtherance. So a variation of these has been alleged, and district courts have considered and oftentimes found that these are in fact versions or potential acts in furtherance of DTSA misappropriation claims. And you can see here that they fall along the lines of the 3 cases that we've discussed so far. So let's jump up 2 slides if we can. So I want to talk with the last couple minutes of my time and then give the remainder to Dan. What are some of the challenges? And these have actually been touched upon by Caitlin and Dan already, so I'm not going to take a lot of time. But personal jurisdiction is often an issue. ITC 337, that's not, but if you want to get damages and you want the full strength of the DTSA, personal jurisdiction can be a big issue. And one way to directly address this, and I think Dan will talk again about this, is the parties' contracts. And one way to strongly address this is by including forum selection clauses and choice of law provisions. And oftentimes courts, particularly in the United States, following Supreme Court cases such as Atlantic Marine, will follow the choice of law and forum selection clauses. And these cases that I've cited here are examples of that, but without getting into greater detail, I'm going to turn the remainder of the time over to Dan to talk about some potential real-world tips that you can use in protecting your trade secrets. Dan?
Well, thanks, Jesse. Before we move on, I want to provide the CLE Code. you'll need to include this code on your CLE verification form, which will be emailed to you following the webinar. And the code is SS6372. That's SS as in Seyfarth Shaw, 6372, SS6372. So now moving on, what proactive steps can companies take to protect their trade secrets? Next slide, please. Well, one of the most important things that a company can do, regardless of where its employees are, is to create a culture of compliance, a culture where employees understand the importance of trade secrets and confidential information, and understand what the company's policies are about protecting that information. And in this, we're indebted to the work done by our friends at PwC and create.org, and some of them have joined us in the past in webinars. A number of years ago, they proposed that all companies follow a 5-step approach in assessing how best to protect their trade secrets. And we think that this 5-step approach is very helpful for pretty much all countries, regardless of where in the world they're located. And this really is an individualized assessment for particular employees, or at least particular employees within your organization, figuring out what sort of risks you have with them. And so the first step is to ask yourself as a global organization, what trade secrets do particular employees in the organization have access to? And that's an important question, because the kinds of trade secrets that a sales employee is going to have access to is usually going to be quite different from the trade secrets to which an employee in R&D has access. And the differing kinds of trade secrets to some extent are going to impact what your strategies are about protecting them. And then the second step is to consider what risks do these particular employees pose with respect to trade secrets. Usually competitors and disgruntled employees pose a potential threat in all companies, but in some industries, there are particularly pronounced threats by foreign governments. And that may be particularly pronounced with respect to certain kinds of employees, such as those that are based overseas. And that might be particularly a consideration if there are employees in areas that historically have less of a vigorous local regime about protecting trade secrets. And the third step to consider is what's the most important trade secret vis-a-vis these particular kinds of employees. The priorities may be different for different types of employees based on the level of access and job functions, and so your strategies might be different. Fourth step is to consider what would be the impact of particular employees or a particular type of employees' theft of trade secrets. If the employee is in a sales role, the major impact might be the loss of customer relationships. For employees in R&D, there may be a risk of a competitor beating the company and bringing a product to market. And so again, that's going to impact the kind of steps that you take practically in order to protect your trade secrets. And then the final step in the analysis is to consider what steps are needed to secure the trade secrets portfolio of your company in light of this analysis. For example, there may be particular training needed for certain types of employees that's not needed for other types of employees. Or perhaps particular policies are needed for particular levels of employees that aren't needed for lower level employees. And again, maybe there are particular types of steps that you have to take in certain regions of the world that you wouldn't have to take elsewhere. Next slide, please. So in light of this, what kind of agreements should you have in place at the onboarding process? So in most cases, a company is going to want to have non-disclosure provisions and perhaps an invention assignment provision in whatever kind of employment agreements you have with your folks. Depending on the type of employee and on the requirements of local law, for some employees, it may be necessary, as we talked about earlier, to have non-solicitation and non-compete covenants, again, if they're allowed. Now, Caitlin mentioned earlier that one size doesn't fit all, and that's as true domestically as it is internationally. As a matter of necessity, most employers will have to operate off of template agreements. There's simply no way to efficiently recreate the wheel every time for each employee. But templates should be a starting point for adjusting agreements to comply with local law. In the US, we recommend having multi-state templates that are adjusted for varying levels of employees, and then having state-specific carve-outs either right in the agreement or in a separate state-specific agreement for the states that have particularly quirky rules. And we're seeing so much activity domestically in the United States from state legislatures that the number of outlier states seems to increase every year. And the same thing applies internationally. Consider what kinds of protections should be implemented for various levels of employees, and make sure that you customize those covenants to comply with local law where those employees work. Next slide, please. So the same analysis applies at other points in the employment relationship and not just at the onboarding process. So for example, when employees are terminated, your company might want to include restrictive covenants in severance agreements if that's permitted by local law. Or you might require employees to reaffirm their existing obligations in exchange for severance benefits. But again, you need to make sure that your approach that you're taking in these severance agreements complies with local law. This is especially important in the international context because in many countries, unlike in the US, certain severance benefits are already required by law. And so you need to assess whether you can tie receipt of benefits to non-disclosure or other obligations. And I'd add, even domestically, some companies will have a severance payment plan. And if you're simply paying what people are already entitled to under a certain plan, you're going to have to give some additional consideration probably to tie these employees to severance, non-compete or other restricted covenants. And I'd say also don't forget creative approaches here. Depending on the threat that a type of employee can pose, you might consider providing employees with incentives such as equity or stock options that are tied to the employee's compliance with loyalty provisions. As Caitlin mentioned, you might also consider requiring certain employees to provide a notice period before they resign. And if it's permitted by local law, you might want to have the option for the company to place certain employees on a garden leave period for some period of time. Again, the laws vary radically from jurisdiction to jurisdiction. Even domestically in the United States, they'll vary from state to state. So you want to make sure that whatever you're doing with respect to these agreements is going to comply with local law. Next slide, please. A few other practical tips. It's important to implement procedures to ensure that employees return all company property at the time of their termination. Maybe that's an obvious point, but it's a point that sometimes is missed. Conducting exit interviews and reminding employees of their continuing obligations can be very helpful steps in this process. And if you don't already have a roadmap for offboarding employees right now, that's a good thing for your company to develop. As a general best practice, it's prudent to coordinate exit interviews among all the organizations in the company that need to be involved. So IT certainly, HR, there might be some other departments. And this, again, might be an obvious point, but IT should ensure that all company property, hardware, and devices have been returned. And that also includes mail, cloud data, and social media accounts. Make sure that the person's access to important IT systems has been shut off at the time of the termination. As long as it's compliant with local privacy laws, it's also a good idea to check an employee's computer activities and work activities in advance of the exit interview. And that's especially the case if there's reason to believe that a certain employee is going to work for a competitor. But again, do ensure that your review complies with privacy laws, which tend to be much more fulsome outside the US than they are in the US. Next slide, please. We're on exit interviews, and again, this may be an obvious point, but employers should make arrangements to have all company data removed from personal devices and ensure that the employee's access to computer networks has been disabled. Again, in compliance with whatever local laws are applicable in this situation. And if the employee has access to the company's social media accounts, you'll probably want to make sure that you obtain usernames and passwords for those accounts. And I should note here that I'm talking about company social media accounts. Purely personal social media accounts are a different story. And in most jurisdictions, including in many states in the US, employers can't access employees' personal social media accounts except in very limited circumstances. You should also consider sending a letter to the employee and his or her new employer, reminding the employee of continuing obligations or putting the new employer on notice of the obligations. You might ask the former employee to provide a written certification of compliance. And depending on the level of the employee and the likelihood of litigation, you might also consider having the employee's emails preserved and forensically imaged. There's some cost in that, at least in doing the forensic image. So maybe not for all employees, it's probably going to be an overkill, but at least looking at whatever emails are on your server to see if the employee may have emailed very important documents to himself or herself via a personal email account. That should not be too much of a cost, and at least depending on the level of employee, that's a reasonable and prudent thing to do. Next slide. Now, finally, after the exit interview, depending on what you have learned about a departing employee, you may need to do a post-termination investigation of certain departing employees' activities. Jesse gave some examples of cases where people had absconded with data. I gave the example of the Motorola engineer who had absconded with data. It's in situations like that where there's a hint that there might be some misappropriation going on that you then really need to consider doing a more of a deep dive, even if you don't at that point have any clear evidence that the person has taken anything. Once again, these activities and these interviews should be conducted in a manner that's consistent with local law. But to the extent that it's permitted, you might interview the employee's coworkers to gauge what they're hearing about this employee's activities in the marketplace. And in my experience, if the employee was a sales employee, his or her former colleagues are going to probably know a lot about what the person's doing in the marketplace because they're going to hear from it from clients and from others. Again, you might examine the employee's email activity, particularly if it's on your own servers. It's a pretty easy task to do. You might want to conduct an investigation of the employee's computer activities. You might want to examine and analyze badge records and access logs to see what this employee's activities were in the last few days of employment. And you might also consider looking at phone records. If the employee had a company phone and you get billing records that show all the calls made, see if there were any suspicious calls made, in the weeks and days leading up to the termination or departure. I'll give one other practical example. This again comes from a newspaper article from some years ago that was published in the Boston Globe in about 2012. And in this story, there was an Intel engineer who had accepted a job with a competitor, but told Intel that he planned to work for a hedge fund and wanted to take 2 weeks of vacation before his last day. While he was still on the company's payroll, the employee secretly began working for a competitor and downloaded manufacturing and design documents worth between $200 to $400 million. Now, fortunately, Intel did a routine review of the employee's email, just as I was talking about, recommending doing. And as a result of that, Intel discovered what the employee had done. Ultimately, thankfully, the plot was averted, and this particular employee was sentenced to 3 years in prison. But the consequences could have been disastrous to the company if they hadn't acted prudently and proactively in reviewing the employee's email. So it's a great example of the value of computer forensic examinations, or even in this case, a very simple review of what the employee's emails were before the employee left. Turn to the next slide, please. All right, so this brings us to our question and answer period. We already had a couple of questions, I think. We've got one for Caitlin. Can an aggrieved company bring RICO sorry, this is for Jesse actually, can an aggrieved company bring RICO claims for trade secret misappropriation that occurred extraterritorially?
Oh, good. Ask the hard questions at the end. So RICO does have an extraterritorial impact. It can apply extraterritorially, but the private right of action associated with it requires a domestic injury. DTSA can be a predicate act of RICO, but with regards to the domestic injury piece, according to Supreme Court RJR Nabisco case, you need that domestic injury. What that means, we've got cases split on that. The Southern District of New York held that the domestic injury is the location where the plaintiff suffered the injury, and you've got the Central District of California that declined to follow the New York case and identified the domestic injury when the defendant specifically targeted their conduct at California with the aim of thwarting the rights in California. So that line of reasoning follows where the conduct occurred, and I'm sorry, not where the injury was suffered, but where the conduct occurred. So good question.
All right, we do have one for Caitlin. Question is, we want to provide non-compete agreements to all of our employees globally as a deterrent, even though we know they won't be all enforceable. Will this create any issues if we do need to enforce the non-compete against a senior employee?
Thanks, Ann. That's a really good question. And the answer is that it can and probably will create issues in a lot of jurisdictions for a number of reasons, but I think one that is probably most important is that even if you are using an agreement that might otherwise be enforceable in a certain jurisdiction, if that agreement is gone to every employee, it really can undermine the argument that the restriction is properly tailored. So said another way, if that restrictive agreement was only used for instance, senior employees, it would be a lot easier to make the argument that the agreement was tailored for those employees versus everybody in the company has that same agreement. This is particularly true if the same restriction is applying across the board as far as geography and scope and time limitation is concerned. I think, courts will look to see, has this restriction been tailored for this person and somebody of this level? And if everybody is getting the same agreement, it really puts the company in a difficult position to make that argument.
Well, that's very helpful. Thank you, Caitlin. One other question we got here regarding the 5-step analysis that I had talked about, and that's how customized should the analysis be? Individual employee level versus job function role department. I think that's going to depend. I think for lower level employees, probably you don't need to do this analysis at the level of each individual salesperson. I think the higher you get in the organization, the more nuanced and unique each individual employee is. And so I think your director of IT security is going to have a very different level of risk associated with the information that person has than somebody lower in the organization. The head of R&D is going to have some very specific confidential information that you're going to want to consider as you're putting these strategies together. Another question, I think, probably for the group here, any comments to the content as to the new Russian sanctions, especially the technology aspects? I can't speak to sanctions, but I think there's certainly been a lot of news out there about the increased risk of hacking and attacks on companies' IT resources as a result of what's going on in the war in Ukraine. I think it's certainly appropriate for employers to be especially vigilant right now as they're protecting their trade secrets, knowing that we've got a particularly uncertain period of time in the world. Jesse or Caitlin, any other thoughts on that point?
I
think
would
that's
echo
right,
those
Dan.
sentiments,
Go ahead,
Dan,
Caitlin.
and I would just add that, you know, we've seen in the news, there's been a lot of Western companies exiting Russia. I think a lot of the strategies that Dan discussed for an exit procedure are really important if your company decides to go that direction, remembering that computers and other company property contain important or may contain important confidential information, proprietary information, and coming up with a strategy of how to collect that equipment, make sure equipment is getting wiped if you're having to go through any sort of termination processes there.
Yeah, I don't have anything else to add on that point. I think we could do a whole presentation on risks associated with the current environment as to cyber malware and hacking and so forth. And I think we do those presentations. And hope you can all join us the next time we do. I think I'll leave it at that.
Great. Thank you, Jesse. Well, that ends our presentation today. As you can see, we got a few resources on the last slide. Please do check out our blog at www.tradesecretslaw.com, where we write a lot of articles about emerging issues in this space. Also, if you don't have it already and would like it, please reach out to us for a copy of our 50-state desktop reference. This provides a very helpful overview of restricted covenant law and trade secrets law in each of the 50 U.S. states, as well as the District of Columbia. And so we encourage you to find that. Thank you so much and appreciate your time.